Now we have an unbelievable panel tonight. So we furnished you notepads, pens, information within your packets there. I'll be talking on a few things tonight. I'm going to cut it real short right now. We're going to lead off the whole night tonight with Rob Corry, who is a lawyer, Denver-based civil rights lawyer. He was named one of America's top lawyers under the age of 40, instrumental in defeating proposals to limit patients' rights. Can we give a big round of applause for our first speaker? And by the way, wait. Every one of these speakers up here is not being compensated for this event, and they donate their time to help instruct you. So a big hand for Rob Corry.
Thank you. All right. Well, the Chinese have a saying, and it's kind of a curse. They say, "May you live in interesting times." Well, we in the medical marijuana industry in Colorado are living in some very interesting times these days, extremely interesting times. And we just got this new legislation yesterday from our governor, Governor Ritter. It's no secret that I opposed this legislation pretty much every step of the way. Significant improvements were made in the legislation. I opposed the final product of it, but I guess more reasonable voices than mine prevailed, and we have this legislation here, at least through the legislative process. I have sued the state of Colorado on a few different occasions successfully about medical marijuana. I think if we can raise the funds and put together a plaintiff group, we'll probably file another lawsuit on these bills. And I wanted to get that out of the way first. We're still doing everything we can to stop these bills, but since this is a business group here tonight, and since this is about continuing to do what you're going to do, what I'm going to advise you is assume that we are unsuccessful in our lawsuit, because it is an uphill battle, there's no question about it. Suing the state of Colorado over a statute, the presumption is against you. I've got to overcome the presumption. Unlike when I'm a criminal defense lawyer, I've got the presumption on my side. As a plaintiff civil lawyer, I've got to overcome a presumption. So my advice to you is assume these bills will become law and withstand any legal challenge whatsoever and be 100% intact as far as you plan your business and make your strategic decisions today. And you'll hear this over and over from every speaker here tonight, I'm sure. There are some major, critical strategic decisions and actions that you must take before July 1st. The time is ticking away very, very fast. Now, I've only got 12 minutes. I'm not going to summarize these entire bills. House Bill 1284, Senate Bill 109, both of them are important. The thing I like about this industry is there's a high level of sophistication among the practitioners. So I would encourage all of you to read the bills themselves. And it's a lot of reading, but it's important. It's important that you understand every aspect of it. It's going to be worth your time to read these bills. Just very, very briefly, let me summarize what I think the legislature has done with regard to House Bill 1284. And this comes from a few years in the medical marijuana industry, both defending people accused of criminal charges as well as helping people get set up and teaching them how to run it legally and answering questions along that process. What the legislature has done, to summarize, is they have created a brand new extra-constitutional methodology to grow and sell marijuana and do so legally at a retail level. What does extra-constitutional mean? What do I mean when I say extra-constitutional? I mean something that exists independent of the Colorado Constitution, a mechanism that exists over and above the Colorado Constitution. The Colorado Constitution, Article 18, Section 14, was added to our state's supreme law in the year 2000 by the voters, overwhelmingly, I might add. The voters of Colorado support this. What the Colorado Constitution does is allows two classes of people and two classes of people only to cultivate, possess, sell, distribute, transport marijuana legally for medical purposes, and those two classes are patients and primary caregivers. Period. Nobody else under the Constitution can legally possess medical marijuana. Under the new statute, House Bill 1284, the legislature has added medical marijuana centers. to the list of people who can legally grow, produce, sell, and possess medical marijuana. And why is this independent of patients and caregivers? Because if you read House Bill 1284, the very definition of a medical marijuana center is somebody who is not a primary caregiver. It explicitly excludes primary caregivers from those who can be medical marijuana centers. Therefore, it must be an additional methodology for people to possess, grow, distribute, and sell marijuana for medical purposes legally under the laws of our state. It is not a primary caregiver. And in addition to that, the definition of person, in other words, the person in House Bill 1284 who can be licensed to do this, the definition of a person includes any number of corporate entities, LLCs, organizations, associations, where in the Constitution, the definition of a caregiver had to be a person over the age of 18 years old. So we always interpreted that constitutional definition to include a natural person, a breathing human being with a heart and a brain. You know, there could have been a possibility of having a corporation that was over the age of 18. That never really came up. So all along we were proceeding as though a primary caregiver must have been a natural person. Now the legislature has given us this brand new creation, a creation of statute, not a creation of the Constitution, because it's independent of the constitutional protections. But as the legislature giveth, the legislature also taketh away. And they have taketh away the caregiver option in any functional manner whatsoever. By taking it away, the legislature has said, first of all, a primary caregiver can only serve 5 patients who have designated that primary caregiver at any time on their optional medical marijuana registry card. Now, I'm well acquainted with the 5-patient limit, having sued the state of Colorado successfully the last time it tried to create that limit because they were infringing on a constitutional right. So the state legislature has reenacted this 5-patient limit. And by the way, a lot of you are wondering, what does the number 5 come from? Who came up with that idea? And the sworn testimony of Colorado Department of Health officials in the Denver District Court, in open court, officials testified that it was the United States DEA who came up with that idea of 5 patients. And I think we all know how supportive the U.S. DEA is of patients and our needs and our rights. So that's the genesis of that 5-patient idea. That's where it comes from, the DEA. So the legislature tells you if you're a primary caregiver and you go that route as opposed to the center route, you're limited to 5 patients designating you on your cards. You're also limited in some other very significant ways. You can't sell the medicine anymore, according to House Bill 1284. You can only give it away. You can be compensated for the costs of producing it, and we're not sure how that gets computed. Because it's unregulated, the caregiver option is totally unregulated by the state. It has no oversight other than the happenstance of law enforcement officers busting in and executing search warrants on residences. So you can't sell it. And there's also this curious prohibition on 2 or more people joining together for the purpose of serving as primary caregivers or cultivating marijuana. I'm not sure how that one gets enforced, but that seems to be a full frontal assault on the U.S. constitutional right of association of people. In America, we have the right to associate with who we want, and the government can't tell us who we associate with and who we can't. So the bottom line is the state legislature has created this very interesting, very exciting opportunity on the one hand, but on the other hand has taken away this well-developed, over the past few years, option to be a primary caregiver and run a functional entity that serves more than 5 patients and delivers medicine to those who need it. So the legislature has done this. How do we respond? Obviously, a lot of us have the decision, and this is a major crossroads for a lot of us, which route do we go? Do we go the medical marijuana center, foregoing our constitutional provisions? By definition, you go that route, you give up your right to be a primary caregiver, at least in conjunction with your activities as a center. The question remains whether somebody can own a center in their work time and be a primary caregiver on their personal time. That is something that is not addressed in this bill directly and probably will not be worked out in the regulatory process, since the primary caregiver route is completely unregulated by the state, other than the Department of Health and its minor role in the process, which